Welcome, everybody. Today, I'm fortunate to be able to talk with attorney Paul Jonna, lead counsel for plaintiffs in a case that, if you've not already heard of it, you likely will as it makes its way through our judicial system to where it could ultimately land at the Supreme Court. The name of the case is Mirabelli v. Olsen. At issue is what's come to be known as parental exclusion policies. These are policies that school districts and various other state actors have developed to encourage and help facilitate public school children's non-biological gender identification. This leads in turn to social transitioning, followed often by what's called gender-affirming medical care that can and often does result in life-changing consequences. The first complaint was filed a couple of years ago in San Diego in the Southern District of California. The plaintiffs, at least the initial ones, were two veteran middle school teachers, Elizabeth Mirabelli and Lorianne West, both of whom had taught in the Escondido Union School District for decades. It's a dense district serving some 17,000 students with over 1,000 certified teachers. The initial defendants were members of the Escondido School District, the California Superintendent of Schools, and various other state officials. Mr. Jonna, in addition to serving in the law firm of Lamandry and Jonna, LLP, works as special counsel alongside the Thomas More Society, that distinguished public interest law firm to protect citizens' constitutional rights, particularly those that fall under the domain of the First Amendment, like speech and religious expression. Welcome, Paul Jonna.
Thanks for having me, Mark. Great to be with you.
It's great to have you here. Paul, I guess the place to start this discussion is to talk about the nature of these aptly named parental exclusion policies. I don't imagine they just suddenly popped into existence. How did these develop in the first place, and how widespread are they?
Well, we do know from our client's point of view, they did seem to just pop into existence out of nowhere. But as we've handled this case over the last few years, we've learned about their origin. And essentially, around 2014, 2015, 2016, folks at the Department of Education were collaborating with special interest groups and developing these policies behind the scenes. And the policies essentially require school districts to unhesitatingly accept a child's assertion of his or her gender identity and not to disclose that gender identity to the child's parents unless the child consents. And these policies were designed for kids as young as 5 years old, K through 8 schools. Our clients found out about them actually during the pandemic. A bunch of board policies were voted into, and this model policy that was circulated by the California Department of Education to every school district in California was just sort of pro forma adopted and voted in on with no notice to anybody. And then there was a training that was given to our clients where the details were fleshed out. But to answer your question, we've now learned that thousands of school districts across the country have similar policies, and they were kind of passed in a very discreet way with very little notice to anybody. And it wasn't until these trainings started that our clients became aware of them.
And I understand that the genesis of these was non-discrimination policies that were on the part of the school policies before, and then they sort of morphed into these exclusion policies. And I guess they include things like gender support plans, including the use of preferred sex segregated facilities, a double set of student records, one for the school staff and students, the other for parents. And the teachers were, I guess, were compelled to go to training sessions in recent years from 2021 to 2022. Is that correct?
Yeah, that's all correct. And our clients never really intended initially to file a lawsuit. They just wanted to be exempt from having to participate in the deception of parents. So they wanted a religious accommodation, and they simply asked, politely, can I have an accommodation? And once the school district said no, and they pointed to the state, they said, well, these are required by state law. So that was only at that point that we filed the lawsuit here in San Diego.
I want to talk a little bit more about that. So this is probably a good time to talk about the initial plaintiffs in the case, Mirabelli and West. What should we know about these two women?
Phenomenal teachers, veteran teachers, as you noted in the introduction, both of whom got the Teacher of the Year award. Elizabeth Mirabelli is an English teacher. Lorianne West is a PE teacher. They had outstanding reviews, positive evaluations throughout their careers, and they just really committed to their students, love all of their students, regardless of their sexual orientation or any of that. This is not about being anti-LGBT. This is really just about properly informing parents and not deceiving parents. And so for them, it was a matter of conscience and a matter of their religious beliefs that they could not deceive parents, because what was happening at the school was they would get a roster and they'd say, and then the school would say, well, here's the students who've requested different pronouns and different names at school, and on that list, it would identify whether the student's parents were aware or not. And if the student's parents were not aware, then the teachers were instructed to use biological pronouns and legal names when speaking to parents, and preferred pronouns and preferred names when speaking with the students. So clearly asking the teachers to deceive parents, and it was only at that point that they initiated the case. But they suffered severe retaliation afterwards, and that's a whole different matter of discussion. But that's the a general overview of those two amazing teachers.
So these are two women. Obviously, they're both veterans. They spent decades teaching. I think both of them were named for Teacher of the Year at various occasions. They both have advanced degree. I think one of them was at Lorianne West, even has a Juris Doctor, even though she didn't agree to practice law, but highly accomplished teachers with no axe to grind in the classroom.
Absolutely. Yeah, that's exactly true.
So I guess around April of 2022, my understanding is in an effort to better understand the policies, the plaintiffs began asking for clarification on these policies. What does exactly mean? How does it work in practice? Which led to the district directing them to comply with these policies, including the use of the student's preferred pronoun. And they were, I guess, numerous instances where they were told to actually hide factual information from the student's parents. And even though they tried to comply with the district as best they could to accommodate them. And I guess some accommodation was given. The district's policy that we are going to stand firm on these parental exclusion policies. We're not willing to bend on that. Is that correct understanding?
So there were two components they initially challenged, and one was the use of preferred pronouns, and the other was the component of withholding information from parents. On the issue of the preferred pronouns, they reached a workaround where they would not refer to any students with pronouns, essentially, just refer to them with last names. And that's really not an ideal solution, but that was probably good enough to alleviate that specific issue. But on the issue of withholding information from parents, the school would not budge, and they specifically pointed to directives from the California Department of Education that mandated adherence to that policy. So that was the narrow focus of this case, which we always thought at the outset would be very uncontroversial to people on the left or the right. Look, this is not about not wanting kids to, even though our clients probably, have strong beliefs on the nature of gender. This is not about a teacher asserting that a kid could not attempt to change, identify as a different gender. This was about making sure parents were aware. So that's a very uncontroversial point from our perspective, and that's the narrow focus of this case. Not trying to stop a student from doing these things, but to make sure that if they're going to go down that road, their parents are aware.
So at some point, the defendants felt they had no other choice but to assert their rights under the Constitution, which resulted in your involvement. And since then, obviously, a lot's happened. Other school districts began passing parental notification policies, basically requiring school officials not to deceive parents about their own children. Rob Bonta, the state's attorney general, filed a suit to enjoin these policies, and I guess he was able to get an injunction. More recently, the California legislature passed what it's called the Safety Act, that effectively bans school officials from being honest with parents about their child's gender identity. And this comes on the heels of other California statutes passed in recent years, like the Menstrual Equity Act, that requires schools to place tampons in boys' bathrooms, or Senate Bill 107, which made California a so-called gender-affirming state and which put California in the crosshairs of the fight to protect our kids' health and parental rights at the same time. So I guess this begs the question, Paul. This case already has some legs on it. Procedurally, what has happened since the initial case was filed? There was a preliminary injunction that was issued, wasn't there, in this case?
Yes, there was. So just to back up, because you mentioned a few different things I want to unpack. First of all, Rob Bonta specifically filed his case challenging those parental notification policies that you mentioned. He specifically filed that in state court. And that's significant because the way these policies are justified in California is by referring to California constitutional rights. And as you know, Mark, as a lawyer, when there's a conflict between a state constitution and a federal constitutional right, the federal constitutional right trumps. So and our case was filed in federal court, specifically focusing on the First Amendment rights of teachers and parents and the 14th Amendment rights of parents. And we did obtain in September of 2023 a groundbreaking preliminary injunction, which found that these policies were likely violative of the U.S. Constitution, both of the First Amendment rights of teachers and the 14th Amendment rights of parents. And it was a comprehensive analysis that we haven't seen before in any of these cases, and it sort of laid the framework for how and why these policies are unconstitutional and how they can be challenged. What has happened since, though, procedurally, is that we've added parents. Initially, this was a case, as you noted, that was filed only on behalf of teachers. And parents' rights were still relevant because our teacher clients didn't want to violate parents' rights. So the court did actually do an analysis of parents' rights in that initial ruling. But we decided, after being contacted by many people who heard about that ruling, to add more teachers to our case, to add parents to our case, and to style it as a proposed class action on behalf of all teachers and parents who are similarly situated. And since then, we've finished about 30 depositions. All of the relevant witnesses have been deposed, experts on both sides, and I would say so-called experts on their side, because they've been their credibility has been substantially undermined. There really is no science or expert opinion that justifies these policies. It's all, quite frankly, not to use a non-legal term, nonsense. But since then, we finished all expert discovery, all fact discovery, and now the case is set for a summary judgment hearing in September, as well as a hearing on our motion to certify the class. And so we're looking forward to, and also a motion to exclude their experts on various grounds. So, what I was saying earlier is the lawsuits that the Attorney General has filed, and clearly to us as an attempt to interfere with the inevitable result in this case, we're all in state court, and those kind of are irrelevant really in the big picture. And because those state privacy rights that they think justify these policies are trumped by the U.S. Constitution. And AB 1955, which you mentioned, is also kind of irrelevant because it specifically carves out any disclosure that's required under federal law. And our case is all premised on disclosures that are required by federal law.
So you did file a Second Amendment complaint, and you added the parties. It's now a class action lawsuit, and you also added additional causes of action. And I wanted to ask you about these, starting with the freedom of speech under the First Amendment, specifically compelled speech and viewpoint discrimination. What should our listeners, Paul, understand about the rights being violated under this cause of action?
So this is actually a very legally nuanced claim because there are some special tests that apply when you're dealing with free speech in the context of government employees. But the very basic concept, and there's different ways of analyzing it, and they're all explained in our briefs. But one basic concept I think would resonate with people is you can't really force someone to say something that would violate someone else's first constitutional rights. I mean, in this case, if you just think about it, it's so simple. The government is asking teachers to engage in speech that would violate parents' 14th Amendment rights. Parents have the right to direct the upbringing of their children, and these policies directly force teachers to say and to not say certain things that would deprive parents of their rights. So that's one way that the court has analyzed the free speech. There are a lot of other tests and so I won't get into the legal weeds, but that is one very simple way of understanding the free speech claim. But the court kind of punted on free speech in the preliminary injunction ruling, and the court focused instead on free exercise and the 14th Amendment. So those are, you know, sort of the court has already established that those are viable and winning theories in this case. And whether or not we prevail on free speech, it's kind of irrelevant, but I think that we will ultimately prevail on all the claims.
Well, you mentioned the free exercise clause, and I also wanted to ask you about that. How do parental exclusion policies burden the religious rights of parents and teachers and fail strict scrutiny?
When you're dealing with First Amendment rights, in this context of parents to direct the upbringing of their children, you don't even need to, if you can establish a burden, then you go right to the strict scrutiny analysis, and you don't even have to show that the law was not neutral or generally applicable, which is another hurdle sometimes.
Right.
But in our case involving the teachers, it was very simple. They have sincere religious beliefs that really are undisputed about the nature of gender and the immorality of lying, and forcing them to comply with these policies is essentially forcing them to violate their faith in order to keep their job. So it's a clear burden on their religious rights, and as far as parents goes, it's very clear too. I mean, these policies, in Mahmoud, the case was about reading books to kids who about LGBT themed issues. And here we're talking about literally the social transition of kids. How much worse is that? I mean, literally facilitating a child's transition to a new gender. So if reading books was a burden on their religious rights under the First Amendment, then certainly literally engaging in a social transition of a child is a much more severe infringement on a parent's religious rights. And by the way, we have in our case a tragic story of one of the parent plaintiffs whose daughter was socially transitioned in secret for over a year at her school. And it wasn't until her a suicide attempt that doctors at the hospital told the parents, by the way, did you know that she's identifying as a boy at school? And they had no idea. And of course, if they had known that, they would have done a whole host of things to help her navigate that issue. But instead, it was only after she literally took her own life that they found this out for the first time. Just exposes the real danger and harms of these policies. But so I don't know if I answered your question, but that's the First Amendment analysis is pretty straightforward, I think, in this case.
You also mentioned the Mahmoud case, Mahmoud v. Taylor. I was curious about your opinion on what impact that decision is going to have on this case, where the Supreme Court ruled that schools must offer opt-outs to parents of objectionable material being presented to their children. And I know that was, I think that was a First Amendment free exercise case, not a 14th Amendment case, but does it have any bearing in this case?
Oh yeah, absolutely. It certainly does. I mean, our point of view was this case, the legal theories and the claims as analyzed by the court, we're going to be upheld on appeal if they were going to be appealed. But now that there's the Mahmoud analysis by the Supreme Court, I think there's no question that ultimately whatever ruling is handed down in the trial court will ultimately be affirmed at the Ninth Circuit. I mean, the case is almost a done deal at this point under that analysis, because it's so strong of a ruling under the First Amendment. So I think it's a significant development that really substantially changes the landscape, and just makes the odds much, much higher that the eventual ruling in this case by Judge Benitez will be affirmed at the Ninth Circuit, and possibly if it goes to the U.S. Supreme Court.
Now, Paul, you also, in your Second Amendment complaint, raised 14th Amendment rights violations under what's this legal concept called substantive due process. And this is part of the class action. Can you explain for our audience how parental exclusion policies violate substantive due process? What is that right?
Sure. So this is a claim. There are actually cases that go back, quite a bit in our nation's history that analyze the right of parents to direct the upbringing of their children and how critical that was in our nation's history. And
Going back to the 1920s.
yeah, and a lot of the focus on the other side has been to say, well, the cases that the Supreme Court cited historically or issued historically were based on violations of rights of parents where medical decisions were being made without parents' knowledge. And so their main theory or their main, I should say without parents' consent, their main attack has been to say, well, these policies don't rise to that level of a medical decision. And even if that was the relevant analysis, our experts have shown with especially in the case of this specific child as a case study that I mentioned earlier, she's being referred to in this case as child Poe. But just to look at what happened to her, well, actually, these policies do have a real psychological impact on children. And in the case of child Poe, led to her attempting to take her life. And we had a very well credentialed psychologist analyze all the records and look at the case of child Poe as a case series. And this is one thing that makes our case very unique. No other case, to my knowledge, has done this. There have been various rulings out of different circuit courts on these policies, and one of them, I think, out of the First Circuit, called the Foote case, and it's pending petition to the U.S. Supreme Court, was decided on a motion to dismiss, which means there was no evidence in the case yet. And the court said, well, we don't think these policies violate the 14th Amendment rights of parents because it doesn't seem on this record that they implicate any medical decisions or rise to the level of, of the, what our other cases have found. And what we have in this case is actual real evidence showing that actually, if that's the relevant standard, they do actually, these policies do have a very real psychological and medical impact on children. And that's supported by our experts, but also by other science that we've included in the moving papers.
Now, finally, you allege in your Second Amendment complaint that defendants are violating statutes, specifically the civil rights laws under Title VII, which is a failure to accommodate a teacher's religious beliefs, but other statutes as well, like what's called FERPA, the Family Educational Rights and Privacy Act. How are these rights being violated under these policies?
So for Title VII, that's specifically being raised for the two teachers, Lori Ann West and Elizabeth Mirabelli. That's not necessarily part of the class action. Those are individual claims that we included because as a result of this whole ordeal, they suffered significant retaliation, harassment. They were both forced to leave their jobs earlier than they planned to, and in very, very unfortunate circumstances. So that's a whole separate, almost a separate case in a sense, but it stems from the same general facts. And so we're going to be that those claims will likely be tried before a jury. But other cases have analyzed that policies like this policy at issue here, in our case, they do violate FERPA, which is a federal law that requires a level of disclosure to parents on certain issues in certain circumstances. And we have a very good argument that the policies here violate FERPA. But again, this is all just extra violations. I mean, we've got all these constitutional claims, but it's just another example, really, of a different legal violation that the policies suffer from.
Now, Paul, you mentioned the toll these policies, these parental exclusion policies have had on real life families. And I guess in your complaint, you cite victims in the Pasadena Unified School District, and then some situations in the Central Valley. I think it's the Clovis Unified School District. But the initial plaintiffs as well, Mirabelli and West, they've really suffered as a result of this. Are they still in the classroom? Are they still teaching?
They are, in the case of Mrs. West, well, both of them are pursuing substitute teaching positions elsewhere. So
Okay.
they were basically kicked out of their schools because of how they were treated. So they were effectively terminated from their positions through the retaliation and harassment they suffered. Mrs. Mirabelli had debilitating neurological symptoms and other medical issues resulting from all the stress of this case and the way she was treated by her colleagues and peers. But so she's still she still has kind of a medical issue she's resolving, but at the right time, she intends to be applying for new positions. And Mrs. West is, I think, actively substitute teaching right now and looking for other opportunities. But yeah, it's tragic. I mean, there's so much to say about how they were treated after the fact, and that's like I said, almost a separate case. But we're gonna pursue that one until the very end to get them full justice.
Now, speaking of justice, you've requested, I think, a class-wide injunction and also what's called a Rule 54B judgment. Can you explain these remedies and why they're appropriate in this particular case?
Well, the class-wide injunction is very interesting because initially we obtained, like as we noted earlier, a groundbreaking preliminary injunction. Now, the case was filed on behalf of Elizabeth Mirabelli and Lorianne West, but the analysis in the ruling was essentially concluding that these policies violate the U.S. Constitution. Now, if you're a rational government leader or actor, you'd read a decision like that from a federal judge and you'd say, geez, these policies are unlawful. We need to get them in compliance with the Constitution. And even though the ruling applies to those two teachers, it wouldn't matter because you're on notice now by a federal court that these are illegal policies. And we've had plenty of other cases where that was exactly what happened, where it was filed on behalf of one or two people, but the government got the message and they fixed things. Instead, here, as you kind of noted in the introduction, the government has done exactly the opposite. They've doubled down. They've filed their own cases in other jurisdictions.
Yeah.
They've worked to pass legislation to undermine this court's ruling. And so it became clear to us that, well, they're not going to do the logical and rational thing. So we need to amend our complaint and make it a class action to make sure that when we get the final relief that we know inevitably we will obtain in this case, that applies statewide and protects everybody, because otherwise they're just going to narrowly interpret the ruling. And in fact, Attorney General Bonta and other government officials sent out notices to every school district updating them on the legal landscape. And it was very interesting when you read those notices. It was a whole discussion about the Chino case in the state court and how sweeping and how significant that ruling was. And then a passing reference to, there was this other case called Mirabelli versus Olsen, but that ruling only applied to these two teachers. And so they were misleading school districts, and school districts got this notice and thought, and basically came away with misinformation about what's really happening. So it was only after that that we decided to amend and add the Attorney General as a defendant in the case and also make it a class action. The 54B judgment really is just a mechanism for allowing this case to, if they're going to appeal the ruling, to let the appeal proceed while other claims that would be tried before a jury are put on hold. So, yeah.
What about the arguments from the defendants in defense of these policies? It appears, Paul, that they are relying almost entirely on a student's privacy rights as outlined in the California Constitution. Is that correct, or am I oversimplifying?
No, that's the main justification. And if you think about how ridiculous that is, think about this: a kid, again, anywhere from 5 to 12 years old, they're saying they have a privacy right where the whole school can know their preferred pronouns and names, but they have a privacy right only as to their parents. So the whole school can find out, but they have some special constitutional right to privacy where their parents can't find out. I mean, that's an absurd position.
It's insane.
That is their position.
Now, if the court grants the injunction or summary judgment, what would be the next steps for implementing and enforcing the ruling across California school districts?
Well, if the court grants the relief we're seeking, there will be a statewide, class-wide injunction barring school districts or state officials from implementing, enforcing these policies. They will be required to, I think they'll have to probably rewrite some guidance to all school districts. They will likely, based on their conduct thus far, they'll likely appeal that ruling. And what we've seen in our past experience with the state, having 9 straight wins against the state of California, what we've seen is that they overplay their hand. And in this case, it's clearly a losing hand, and they're going to just appeal this case, and it will only backfire on them. It will result in a appellate decision that will be binding much more broadly than it otherwise would be. And they'll have a much larger attorney's fees built into this. But hopefully things can get, we're always open to talking about ways to resolve this. And the state, unfortunately, they're so politically motivated that a lot of times practical solutions don't even hit their radar. I mean, there are practical ways of resolving this, and they should be able to read the writing on the wall at this point. I mean, this is not going to end well for them. But instead, doubling down like this, and a lot of times we don't know why they do what they do, but they're politically motivated people. Maybe certain people want to run for governor. Maybe they want to get the endorsement of a union. We don't really know what's motivating them, but at the end of the day, we're very confident it's going to result in a very sweeping and protective appellate decision that will only solidify teachers' and parents' rights much more firmly in the future.
From your lips to God's ears. Now, I have to ask you, Paul, what motivated you personally to take this case on? I guess more broadly, how do you see it fitting into the broader landscape of constitutional legal challenges today in our country?
My partner, Chuck Lemandry, has been involved in religious liberty work out here in San Diego for 30 years. He defended the Mount Soledad Cross case, which went to the U.S. Supreme Court, and he's handled a number of these cases. And I was at big firms, and I was growing in my faith, and I was introduced to Chuck, and I was very convinced that lawyers like us need to band together and do what we can to help fight this battle. Whether we win in the long run is up to God, but I know we're winning battles that he wants us to fight, and so this one was very near and dear to our hearts because Mrs. Mirabelli, she approached the Thomas More Society. She set forth what happened, and we were both blown away. Everyone here was blown away. We had never heard of these policies. We've never were aware that this was happening in California. And so we started slow with just trying to see if we can get her an accommodation. And then as we researched and learned more, it became clear that this was a very compelling case, and this was a very widespread problem. And so we decided to do everything we could. And Thomas More Society is based in Chicago. They are a public interest firm that offers pro bono legal representation to clients like ours in this case. And so they're a great organization to learn about and to support, and you can learn about them at thomasmoresociety.org.
So the next milestone in this case, I understand, is the motion for summary judgment hearing that's going to occur when? Is that September?
September 29th.
Okay, and we're going to be watching this case very, very closely. In the meantime, Paul, what can parents do to ensure transparency and accountability in their local schools, regardless of how this case turns out?
Well, I mean, the parents in our case were very proactive, and they were asking, and one of our parents would regularly, they knew actually they later learned, this is not child Poe, it's a different parent, that their child was suffering from some gender confusion. And so they asked the school, well, what name is she going by? Can you tell us more about what's happening? And they were outright just telling her, no, we can't tell you. And they hid things from her. And so they were as proactive as a parent could be, and they were still lied to. But I think exposing that and creating that written record is important. So I do think parents, obviously, you need to be very involved in your child's life and make sure that, social media, unfortunately, is such a big problem for youth, especially young girls, and is causing a lot of confusion. But being involved in their life, but also knowing what's happening at school and being very involved. And I know it's a very general answer, but unfortunately, you can be very involved and still be lied to by the school. So I think exposing that and following these cases is very important. But I think if there are specific issues that parents want to raise or they're concerned about, they can always contact the Thomas More Society.
Well, in my humble opinion, Paul, this is one of the most important cases in the nation right now, and we could very easily go on for another hour discussing it. Unfortunately, we're going to have to leave that for another day, but I hope, Paul, that you're going to allow us to check back in with you again as this case unfolds, In the meantime, I want to thank you for the work that you're doing on behalf of our nation's children and parents, and also that of the Thomas More Society for its indispensable advocacy on behalf of religious freedom and parental rights. How can people support you and your work? Is the website the best place to go to offer that support?
Yeah, the website, thomasmoresociety.org, and there's ways to contribute to the Thomas More Society. We serve as their special counsel in California, which means we handle the cases that arise here in California. But thomasmoresociety.org, and they have cases across the country. They're fighting a lot of and winning a lot of really important battles. So it's a great organization.
Well, let me leave it with this. I'm reminded of the great civil rights leader, Martin Luther King, who said that our lives begin to end the day we stop speaking out about things that matter. And there are few things that matter more than the sacred duty to protect the innocent from harm in whatever form it comes. But it's particularly egregious when it's coming from public school servants at taxpayers' expense. So the time to make your voice heard has never been greater. And I want to encourage our listeners, for more information, you can visit our website at pok.org, and please subscribe to this channel. In the meantime, thank you for listening. Thank you, Paul Jonna. I'm Mark Schneider for Protect Our Kids.